Recording in progress.
people made requested to address the committee in terms of the oral submissions. I think it's important to state that in some instances, people did not have presentations, but they had their initial submissions. But some in the submissions they've made, they would have made specific presentations which would improve or review or redetermine. I wouldn't know which one is specific, what they would have initially made. I think the first thing is the issue then that we are dealing with the ERA bill. If the committee allows, there are two issues that we think before we deal with the ERA bill is just to bring to the attention of the committee and probably suggest what will be the way forward. But we all know that public hearings will split into two. The first one is the request for written submissions, and then the second one was the issue for provincial public hearings. And we had to deal and finalize these two processes. And I think when it comes to the written submissions, we have dealt with that part. And then there's the issue of the public hearings. I think in the main, what we thought is important is to give a feedback now on the issue of the provincial public hearings. Maybe before I do that, is it correct that currently we are all dealing with oral submissions and written submissions?
Yes. Look, the oral submissions which were done on Thursday and Friday was basically a summary of the written submissions submitted. So yes, so we are dealing with the written submissions now, and simultaneously the provincial public hearings which ran up until 30th November, Chair. Yeah.
Or even the provincial public hearings.
Yeah, these are two different processes, as you've indicated, Chair. Yes. On public participation, correct. So it's the written submissions, which we are busy with now, and the other process up until the 30th of November. But now, as you've indicated earlier this morning, now the issue is the 3 legs, which we did not do.
Okay. Yes,
to be included in the consolidated report.
Yes, I was trying to say the department for now is responding on the written submissions.
Correct.
And, yes, but I think it's important that that's why I was saying, honorable members, there was an issue in the morning which we think we need to dispense with and also respond on the issue by Honorable Mahlauli. There are two issues. I'm not sure if members want us to circulate the second part with regards to the provincial public hearings, which we think we can quickly dispense with. We will make proposals and also look at the issue. The first question was with regards to the outstanding 3 provincial public hearings, which is Zerast, the Zerast,
Bethlehem, and Galcom.
And Honorable Mahlauli says, no, we should be going to Parliament and ask Parliament whether we should, they are ready to address some of the things that were causal effects in the non-materialization of the public hearing. We might have thought wrongly. We have interacted with the administration in terms of the committee. The advice that we received was that it is the committee that must decide whether it wants to revisit those 3 public hearings. But the view is that the committee does not have an option in reconvening, except if that application or request is denied. So the matter is placed in front of the committee to make a decision whether it seeks to repeat or to reconvene those public hearings and then inform Parliament of its intention to reconvene those public hearings on the basis of what was lacking. Only then, if the committee agrees, I think there is a proposal that we have worked out on what do we think could be the dates that those public hearings could be conducted, and subsequent to that, we will do the normal procedure and motivate why those public hearings have to be reconvened. I think that is the first part. Maybe let's dispense with that first part to honorable members. I'm not sure from the administration side or the committee side staff, is there any matter that you want to also add on the first part with regards to the provincial public hearings, not the correspondence that we are going to deal with it later on from one of the institutions that we interact with. Is that Ari, Ayanda, or Parliamentary Legal Services, or Sivu, or Mashodu?
Chair, if I may.
Yes, Honor, is that Honor, yeah, or Advocate Jenkins?
That's right, Chair. Yeah, the issue of those public hearings that did not take place, as I said in the committee previously, we must just record it properly. What was the reason why that didn't happen? Because in the end, everybody is entitled to get their opportunity to make public input. So if it was a logistical problem on Parliament side, then we might want to just indicate to the people in that area or ask the people in that area if they don't want to submit written submission, if we couldn't do the physical meeting there. But we can't close the door without getting their view, Chair. That's all I want to say. Thank you.
Okay.
You, I've unmuted. I'm talking to my. No, I was saying, is there any other, sorry. I was saying, is there any other person from the administration that would want to make an addition? I saw there, I was saying, I see the hand of Honorable Mahlaude, but I now realize I was talking to myself. Before I go to Honorable Mahlaude and other honorable members.
Okay, let me just add, Chair. Good afternoon, honorable members. Yeah, just to add on what Advocate just said now, I support as well that the committee, for me, I would argue that the committee must go back to those 3 areas because we had planned, we had those districts in our program, and we were there physically. We went to the walls. And we realized that there was no mobilization done, but there were people that were there in the wall. So an expectation has been created already. And I think we might be challenged legally if the committee does not go back there. Thanks, Chair.
Okay, I get it. It might be. Okay, Honorable Mahlaude, is there any other member who would want to come? 1, 2, 3. Okay, Honorable Mahlaude.
Thank you very much.
After you, there's Honorable Treza.
Thank you very much, Chair, and greetings again. Chairperson, when the second meeting failed, we acknowledged that it is clear that the fault is on our side as Parliament in terms of mobilization. So there's no issue about why we failed. We know why we failed. It is the parliamentary people who are tasked to mobilize who did not mobilize. Now, what did we do then? When the second meeting failed, we had what we call a preparatory meeting. We were preparing for something else. In that meeting, we did say to the chair, go and interact with Parliament so that we go back and do those three. It was two at that time. We said go to Honorable Frolic and apply that if possible, we would want to do the three legs. As I indicated, it was two then. Maybe because that was a preparatory meeting, but in any case, members of the committee sit. Maybe we want to cement it here in a formal portfolio committee meeting and say, we have tasked the chair, or we are tasking the chair to go and make an application that we would want to do the three legs that are left in areas where we went and we failed to mobilize sufficiently. And when chair comes to us, he will be saying, we are not going to suggest dates. He will be saying, these are the dates that we have suggested with the staff. Do you agree with them? Are they convenient to you as the committee? I don't see us sitting here and trying to find dates where we're going to do those three. The office of the chair must come with dates and say, these are the dates we have applied, whether pending approval or approved, we'll see it then. Let's go and do public hearings, because we have to do those public hearings, because we even acknowledged in radio interviews that we were at fault. Remember, when the staff of Parliament does something wrong, we have to take responsibility and say, Parliament did not mobilize sufficiently. It doesn't matter how much we whip them, how much we take them to task and all of that. At the end, Parliament did not do the work. Thank you very much.
Okay. Honorable Gaza.
Chair, you will forgive me because I'm in powers and privileges committee, and I must split my mind in terms of what's happening. Chair, please allow me not to flight my video due to those circumstances. Chair, oh, thank you very much, Chair. Chair, I was not part of the public hearings then, but I pick up that, Chair, there's the issue of Zerast, Bethlehem, and Welcome, as Honorable Mahlaule has just told us right now, and the legal team and the administration. And I'm worried, man, Chair, in terms of going into a planned meeting, and then you don't get the necessary support because of the mobilization. And it precipitates a question, it compels a question, actually, that who is to account for that mobilization? And the second one, the curious one,
is whether this does not have direct implications in terms of the fiscus chair and the expenditure. Will it not have in terms of the Auditor General's report, in terms of wasteful or irregular expenditure, whatever category of expenditure is there? Because it sounds like, according to Honorable Mahlaule, it sounds like you went there and you couldn't find people, and a perception was created that there would be meetings and you could be held accountable legally for not discharging your duties in terms of holding those meetings. So those are the two curious questions that I have, because the one that I had before about what has caused, it has been answered by Honorable Mahlaule that it is a mobilization. But I just have the two, who's to account whether it would not have negative implications in terms of the audit, whether it would not have the negative impact in terms of the fiscus, the budget of the department, as it were. But I think it's worth that people might find, we must find measures in which people can express themselves in Zeerust, Bethlehem, and Welkom in terms of any other means, even if it means that we should extend the period of the closure of the return submissions as they expired on the 30th of November 2023, or go there physically and continue in terms of the permission that we'll get from the chair. I think those are my submissions. Thank you very much.
Okay, honorable members, let me say this. the issue with regards to this is a provincial public hearing. The first issue was that there has to be correspondence, and the correspondence was sent to the House Chairperson with regards to the failure of those public hearings. But it required the committee in its sitting to then agree that it of the view that public hearings in those three outstanding areas, based on the reasons, which I think accurately Honorable Mahlaule captures. Can you agree on one thing? One, I did say that there are proposed dates that we're looking at. If the committee agrees to reconvene those public hearings, I get it that there's agreement that the public hearings be reconvened, and we'll make that required application. But I think for the benefit of members, we'll give them an opportunity to go back, but we'll send them, or we can even flight out the proposed dates for the public hearings. Two, I think it's important just to help Honorable Kaiser. It is not our duty, but we did it. When we compiled we finalized, it's already done. When we finalized the report of the provincial public hearing, that consolidated report, I think you are correct what you say. We will then factor in what could be the cost implication for each public hearing that we convene and did not sit, and what will be the sum total of all the three in terms of, as you say, cost to Parliament, not department, cost to Parliament. But the other issue that I think it's important that has to be noted is that I guess that's what Honorable Mahlaule is saying, we must write to Parliament and say we want a guarantee from Parliament that these public hearings, as we reconvene them, proper mobilization and public education will be conducted. I think that's the message, so that we don't go back there and find out again what was the reason for those public hearings, not to resume, to convene, is not the same reason when we reconvene. We need that amount of guarantee. And I think we can do that as part of the application that the committee has resolved to reconvene those 3 public hearings. There are proposed dates if honorable members want us, or we can send them to yourselves. If there are misgivings, members can just do what we call round robin on the check. Also, the availability of members when we do those public hearings. Or Ari, can you flight those dates whilst that are being proposed in the meantime? Or can you
I'll
mention
them, Ari?
Okay.
Or can you mention them by head? It's taking.
Oh, just speak to the dates, Ayanda.
Sorry.
Oh,
Okay, apologies, my computer just frozen now. Okay, here are the dates. The proposed dates are from the 26th. We said it's Bethlehem, and then 27 it's Welcome, and then the 29th is Yarast. Chair, there's an oversight week where we put also some mines to be visited in terms of the health and safety issues, which includes the Harmony Gold that is in Welcome. So after the hearings, the intention is to also do some oversight in the afternoon for Harmony Gold, and then we move to Northwest, doing public hearings in Yarast, and then we'll go to the Imbala, where there was a recent incident, and also Sibanyo Gold. Thank you, Chair.
Okay, honorable members, that is what is then being proposed in terms of what we are dealing with. If there is consensus, then let's agree that from the chair, we will then make the required and the necessary application by tomorrow, so that there is no complaint about not giving enough time. Can I take it that there is agreement that we are reconvening and we must make the application as a matter of urgency? They say silent means consent. Like I said, that the issues that the members have raised, including the question of consequence management, I think that's what also the committee had raised, to check what steps have been taken to those who have failed to perform their duties, which would have costed so much. And that's what we will do with regards to that. The second part, honorable members, I want to suggest that we deal with this when we do the report on the public hearings, the consolidated report, in particular on public hearings. But I would suggest that if members also agree, allows us, we send you the correspondence. We received correspondences, if I'm not mistaken, 1 or 2, but there's a recent one that is from Makua Amoa with regards to their concerns about the provincial public hearings. If members agree, I'm just summarizing. I didn't go to the detail. To my engagement with the, call it, I don't like to say the committee staff, we're of the view that those issues can be contained and be dealt with when we have finalized all the provincial public hearings, we're working on the consolidated report. And then the committee can express its views on such a correspondence because it relates to the provincial public hearing. That now we have agreed that there are some that will reconvene based on only then when we deal with the consolidated report, we can also deal with the correspondence of Makua Amur. Am I all right, my committee staff, including the Parliamentary Legal Service, before I take any member who wants to comment on it? When you are all silent, it means I've represented you well.
Yes, my side is clean, Chair. You've represented my side. Thank you.
Okay, honorable members, do you want to take? I'm sure we agree that we will deal with that correspondence, but I will ask Ari and Ayanda in the meantime to send those such correspondence to honorable members.
It has been sent previously, Chair, and even this morning.
Okay, then if that is the case, honorable members, then I don't want to know, is it because there is a different session? Do we again take apologies?
Let's do that, Chair.
Sorry, Honorable Maling, I see your hand.
Greetings, Chair. We have been battling. I've just asked Ari and Ayanda to send me this afternoon's link because I've been using the morning link and it said waiting for the host to start the meeting. I thought, hey, it's unlike them. Mara, then I said, hey, it's December anyway. Chair, I want to zoom into this issue of Makua and Wamoa. But I take your guidance, Chairperson, that we will deal with it after we have consolidated your office has consolidated the public hearings. Mara Chair, I want to reiterate what we have been saying as this portfolio committee, that we can't be held hostage by one stakeholder. All the time they threatened to litigate us, but they followed us throughout the country. So I'm not sure what they mean when they say the community, because they represent the community, Mosbon. The community was not given fair chance to participate. But let us deal with the Chair after we have reconvened the three remaining districts. We will deal with the aspiring political party in the name of Makua. Thank you very much, Chair.
Okay. Honourable members, let's take it. I always say we accept anything when sub correspondence is sent. It is not for me, nor for the staff. It is for the committee, especially if it is directed to the committee. 1, 2, let's deal with the issue. Like I've said, at the appropriate platform, that as we compile the final reports on the provincial public hearings, we will take into cognizance the issues that they have raised. Let's deal with it at that level. Okay, in the absence of, in that note, can we give now the department to respond on the submissions, both oral and written submissions? Because there are people who would have had written submissions but did not make any oral submissions. And some would have made presentations that are an improvement from the one that they would have presented. Ari, you wanted to come in on the issue whether we need apologies or not?
Yeah, let's do the apologies, Chair, since this is a new meeting.
Okay.
So yeah,
are there any?
There are, Chair, Mr. Lorimer, who's unable to attend the meeting. And then we've also received the apology from the Minister, who's attending a prior commitment in the Northwest, Chair. Those are the apologies received, Chair.
Okay, dear Marie. Can you come in? Welcome, DG. I saw you again. If I leave someone high up, please, my apologies. Can I give it to you, dear Marie?
No, thank you, Chairperson. Once again, good afternoon to you and good afternoon to the honorable members. Chairperson, I will not also waste time with this presentation. I'm going to hand over to the team that is with DDG Ngwabe to deal with the response to the questions. Over to you, DDG Ngwabe.
I see she was out of the meeting, but I've admitted her now.
We'll be flighting the presentation in the meantime.
DG, they indicated earlier that I must give it to Jacob Maraba, but I don't see Jacob on the platform.
Apologies, I'm just trying to get hold of DDG.
Apologies, DG, I got kicked out. I'm back in the meeting. Apologies, Honorable Chair.
Yes, we can proceed, ma'am.
Okay. We are struggling a bit with connectivity. Can I ask, Honorable Chair, good afternoon once again, and honorable members. From our side in the meeting right now, I think Mr. Maraba is also struggling with connectivity. It's myself and Ms. Ramunchi who will go through the table. Ms. Ramunchi, can I ask that you fly it from your side so that it's easy when you control the table from your side? Thank you, Honorable Chair. Thank you, DG.
Is Mera Munshi on the platform, man? So I can give her co-hosting rights.
You're sorry, I'm saying I was checking that I can't see her here or him here.
Am I audible, Chair, from my
Yes,
side?
we hear you very well. What we can't see is your presentation.
Okay.
Ari, you can't flag it from your side.
I can, Chair.
Please do.
Let me open it quickly.
Okay, thank you. Thank you, Honorable Chair. So the presentation will follow a similar approach as we did with the NNR bill this morning, where we go through all the comments that we received and the responses that we have formulated as a department. And the grouping in this presentation is in terms of sort of comments that are speaking to one issue. And then in our responses, we will also make reference to the relevant sections. So generally on unbundling, which in some of the comments, it was referred to as privatization of Eskom. What came out is that labor unions are not necessarily in support of the unbundling or the restructuring of Eskom, and the invitation of private players into both generation and distribution, and therefore the rejection of the establishment of this TSO and proposals for Section 30 to be removed. So our response is that this is noted. These comments do not necessarily speak to specific provisions, but what we are making, the point we are making here is that the whole point around the amendments to ERA is mainly so that the TSO could be created. And this is as per the Eskom roadmap, which was published in 2019, as well as the announcement by President to say that Eskom will be restructured and reconfigured. So from where we sit, we note the comment they are making, but our proposal as the department is that the clause Section 30 remains as is proposed. Can we move to the next one, Ari? Yeah. Then on the definitions, BUSA and EIUG, Energy Council, Eskom and NICOM, the comments and proposed definitions, and proposed definitions provided have been noted. The comments that they are proposing do not necessarily address specific issues in the current bill, but they were referring to the bill in the 2022 bill, and some are not. It's like no alignment to the bill in front of us when you look at the comment against the comment. Most of the proposed definitions are definitions which are already defined and are contained in the bill. So to provide clarity and eliminate ambiguity, these definitions were consulted and deliberated at length at NEDLAC and agreed upon. Next page here. And then on the transmission development plan, which is a plan that is put together and published by Eskom, the definition, they're saying the definition should be reinstated with correct cross-referencing in terms of the section, the 2022 amendment bill, and the proposal for the definition and responsibilities regarding the plan as they were included in 2022 should be reintroduced. I think on the reintroduction, what we are saying is the transmission development plan, as I indicated, is a plan developed by Eskom for the national transmission power system, and going forward will be in the hands of the transmission system operator once the TSO is in place, and will be published by Minister, and that has been covered sufficiently in the bill. So we are proposing that the wording in the bill stays as it is. And then there was a specific comment on the IRP, which is the Integrated Resource Plan, where they were saying the IRP should not lock in technology options, but make it clear that technologies are only indicative recommendations. The final allocation of technology should be left to Section 34 determination process. The comment here is noted, but not necessarily supported, because if the proposal is as crafted or as put before Parliament, it means that the IRP must be silent completely on the technologies. And I think we must mention here, Chair, that we don't just sit and decide on the technologies. We use a scientific method where we model in the system based on the power system requirements, and the model then builds what is required and what capacities, and that is then becomes the outcome, which then goes out in the IRP. It's not a question of we can decide to say the IRP will be quiet and the Section 34 determination, because then there would be nothing to base the Section 34 determination on, basically, because when a determination goes out, it's based on, it's literally giving effect to the IRP. So our proposal is that the wording stays as is, and we leave the IRP process to be the IRP process, which is scientifically based on the basis of a proven model. A comment on the Central Purchasing Agency. The proposal is that it would enhance reliability of the transmission if the CPA is not limited to during the transition only. We understand there would be only one CPA and such propose instead of a before CPA as a point of clarity. So here it's the, again, Central Purchasing Agency currently exists within Eskom, and that's where all the PPAs that Eskom enters into with the IPPs enters into contracts and agreements. And we are saying that insofar as that comment is concerned, the comment is noted and supported. These comments, however, do not address a specific provision in the bill. The CPA will continue to manage the transition to manage the process post the transition period, because there will be legacy IPP contracts in place. For example, there are currently IPP contracts that Eskom has entered into for a period of 20 years. So those ones will continue to exist into the future, and the CPA office will continue to manage those. Okay, again, it's just a question of mentioning physical contracts, and for us, really, physical contract is exactly that there are contracts that have been entered into, and there will be contracts to be entered into with the TSO going forward, and the CPA will continue to manage those contracts. And there was a comment also on vesting contracts. The proposal is that there is a deletion of specified price in the definition of vesting contracts and be replaced by a price determined by the regulator. And there is a proposal for a definition for a vesting contract to mean a vesting contract as defined, as written in front of us. And we are saying we have noted this comment and we have supported the deletion of a specific price to be replaced by a price to be determined by a regulator, because the regulator will always have to play a role and set parameters insofar as pricing is concerned. Otherwise, we run the risk of having some segments of the community or the public finding the prices being unaffordable overall. Physical bilateral transactions, there's a proposal of a definition of a physical bilateral transaction to mean a transaction entered into by generators, customers, and traders, which involves the conclusion of a PPA to meet a demand and supply as required by the system operator. The comment has been noted and supported for the amendment of the definition, and we will then rework the wording to have this insertion reflected as such. Transmission power system, again, a proposal on the definition. Again, we have noted and supported the proposal to expand the definition so that we include assets that are approved by the regulator to be part of the transmission power system. Otherwise, if we do not, then we will have a gap in the legalities in terms of where do those fall and where are they regulated. So we saw it as bringing them to the control of the regulator as well. Price and tariff. There's a proposal that a distinction be made between tariffs for the supply side of electricity industry, and there is a cost of providing a service, and a price, which is the price of the end consumer. Again, the comment here has been noted and supported to provide a distinction so that there is clarity and we eliminate ambiguities in the legislation. And this distinction, we believe, is also important. So we are proposing an insertion to address that issue as has been raised. Okay. So from NICOM colleagues, there are also recommendation to define balance responsible to mean taking physical and financial responsibility for maintaining real-time balancing at specific metering points. This, we had a bit of a discussion around this. It has to do with the fact that when a system is in place and there is that common platform, trading platform, there has to be real-time balancing of the entire system all the way to the metering points. So we noted this comment, and the definition we are saying balance responsible, the definition that we have currently carries the same meaning as proposed. So for us, we felt that that has been covered sufficiently when we looked at it. Balance responsible party need not be a licensee, and the following definition is proposed, that it means an entity for balance responsible activity, which is accountable through the balancing mechanism. The comment here is noted, and we feel that again, in this instance, the current definition that we have carries the same meaning as proposed in the comments. So we are proposing that we retain it as it is, Chair. Balancing mechanism, again, proposal. We note and support the proposal to redefine the definition of balancing mechanism, and we will accordingly provide an insertion or a working of the text in this regard. Distribution facility is not defined in the applicable electricity regulation or ERA bill. As this term is used in ERA, it should be included in the main act. The comment has been noted and supported because the term is used more than once in the bill, so it has to be properly defined in the legislation. There's also a recommendation to say distribution licensee must be defined to mean a holder to operate, and we said we will also look at that definition. On distribution power system, the absence of a distribution facility definition, the proposal is to revise the definition. And how we looked at this, we're saying it has been noted and supported. So we will be defining the distribution power system to mean a power system which operates at a low or at below a nominal voltage of 132 kV. And we're talking about it again late last night to say this, we can simplify it like this, but as we continue to receive comments, we will also take time to take a deep dive into this. But principle is we accept that we have to provide clarity on this definition. Direct supply comments. The comment is around the fact that the definition currently does not cater for the electricity supply industry transformation. The distribution business is not only related to the wires business, but also retail. And we're saying we have noted the comment, but the bill defines the direct supply agreement as an agreement for the sale of electricity between a licensee, a generating licensee, and it's acting as in its capacity as such, and a customer, whether such electricity is supplied directly or through a transmission power system or distribution power system. So the proposal is that we amend to include private generators. Other than that, the bill definition has the same corresponding meaning as proposed. So it's just the insertion to cover private generators. On the market operator, there's a proposal for that distributors should be allowed to participate as market operators and market participants. We have noted, and there's a proposal there at the bottom, recommendation. The comment is noted but not supported. We feel that the comment does not necessarily address a specific provision in the bill and has no bearing on the provisions of the bill. The role of distributors in a competitive market must be investigated given the current challenges faced by distributors. And we looked at also previously when we were drafting benchmarking, how is this done in other countries? And once you have a TSO, it's your one market operator or system operator, and that central point of trading, having that central trading platform as opposed to having multi ones. I think there was one case study we looked at from South Korea, I think, where they had multiple and it failed dismally. That's why we stayed away from each one. But also two, this is about also giving effect to the ESCOM roadmap, and it does not. System operation, there was a comment that we need to define the distribution system operator and its relationship or role to the TSO. We have noted the comment and supported. However, it does not necessarily address a specific provision. We will be looking at the role and relationship of distributors in a competitive market, given the current challenges, as well as to say, how do we provide clarity? Some of these, Chair, we were saying it might not necessarily be covered in detail in the legislation, but the details usually go into the regulations as long as we provide clarity in the definition section. Then there was a comment on the trader. Following definition of a trader is proposed, and on this one, the proposal was that a trader, the definition must say a trader means a person who trades in electricity and related electricity services. Comment is noted, but not supported necessarily. Because we see the trader as a trader forming part of the parties assigned to be the balance responsible. If you look at the definition above, that's where we saw that it is sufficiently covered. Okay. Reticulation, again, there's a proposal on the reticulation. The comment was saying the issue of a lack of a proper definition of reticulation is creating challenges within the municipal space in terms of exclusivity of their supply areas. And the suggestion was that it would be better to define reticulation properly and put the rest to current challenges relating to municipalities' rights. Comment has been noted, and the comment speaks specifically to 2A. And there we are providing a bit of a legal context to the extent that local government plays an important role in electricity industry in South Africa. Schedule 4B of the Constitution lists electricity and gas reticulation as a local government responsibility. And this is again linked to Section 153 of the Constitution, which places the responsibility on municipalities to ensure provision of services, and that includes electricity and reticulation thereof. So the recommendation is supported to define a reticulation in terms of infrastructure only, because it is about infrastructure, distribution infrastructure at a municipal level. And that is the proposed insertion. Then there was a comment to say that there is a need for a definition for retailing to deal with selling to end users, and we have accepted this proposal. As is, we have not supported this proposal because the bill does not contain any provision relating to the terms retail. These terms appear in the bill as part of a definition of trading. So the department does not accept the proposal to insert this in the definitions section. Another comment on the feed-in tariff. Renewable energy feed-in tariff, a mechanism to promote the deployment of renewable energy that places an obligation on specific entities to purchase the output from qualifying RE generators at predetermined prices. This proposal we are not in support of because the Principal Act and the bill does not contain provisions mentioning the terms feed-in tariff or renewable energy feed-in tariff. So these do not appear in the bill, so we cannot support this to define something that is not mentioned in the bill. So comments from Natural Justice and Center for Environmental Rights. The comment was that apologies for the typo there, is that ERA lacks certain key definitions and regulatory clarity regarding new clean energy technologies such as energy storage and its potential services. The comment is noted. Again, the bill does not provide for definitions and terms that provides for definitions and terms that are used in the legislation and for which technical clarity is required to distinguish their use from ordinary meaning. So some of these we thought, Chair, they are asking for definitions to be inserted, but there are no specific sections in the bill that talk to that. We've had instances previously where even the state law advisor would delete such definitions because you are defining something that's not in the body of the instrument, the regulatory instrument. Direct supply agreement, NERSA should not regulate the pricing or revenue of private enterprises. There was therefore a request that the definition of direct supply agreement be amended as such in the recommendation below. To be an agreement, that means an agreement for the sale of electricity between a generation licensee or registrant or trader acting in its capacity as such and a customer for which electricity is supplied directly. This comment has been noted and supported because our definition, we thought, omitted the private generators or registrants acting in their capacity and can enter into these agreements. So we will be making that insertion in the bill. On regulated transactions, the definition of regulated transaction in the 2023 Amendment Bill should concern itself only with transactions by regulated entities, which should be state entities. And there is the recommendation that was given to us. The comment provided has been noted. However, we are not necessarily in support of the comment because the definition provided with specifically exercise of market power is likely or evident that transaction must be regulated to avoid market power abuse. So we had to look at that as well to say what is the potential for some players to abuse the market. And we thought we would retain the wording of the text as it is. The next one is a comment received from Cecil, where Cecil was making suggestions, again, on a legal definition, given their important role to the text of the bill. They're proposing definition of competitive electricity market, network grid, integrated power system, market operation, transaction development plan. And the interpretation is that the regulated transaction is one where tariffs are set by the regulator. And they were saying that definition creates confusion as it may include projects that need to be registered. And there's a recommendation at the bottom where they're proposing a more streamlined definition. And this comment has been noted, but we, however, are not in support of it because we believe that the definitions found in ERA Bill 2023 were discussed and debated at NEDLAC, and none of the definitions legalities were questioned, but also we subjected them to the state law advisor scrutiny. I think that is a continuation of that comment from Cecil. A comment, the next one is from Sawea. Sawea noted the additional definitions, including those for balance responsible or balance responsible party. However, the role of traders in the balancing mechanism is not clear, and they are asking for clarity. The comment has been noted, and the bill has included the definition of balance responsible and responsible balance responsible party. I think we did speak to this in the earlier sections when we start in the beginning of this table. And then there was the noting of a definition of direct supply agreement, excluding registered generator. Again, in an earlier section above, we did talk to the fact that we amending to include registered generators. We can go to the next one, Ari. Alternative Information and Development Center comments. The comment is around the fact that the bill proposed reforms will undermine the state's capacity to achieve the efficient, effective, sustainable, and orderly development of the electricity supply, and will result in added risk on state finances. And there was a recommendation to end the process of setting up the TSO to facilitate a shift to a market, an open market or competitive market, maintain Eskom as a vertically integrated utility. Again, the comment here from us is that we note this comment, but are not necessarily in support of it because firstly, it does not address any specific provision, but secondly, this whole TSO establishment is the main focus of this bill and the main purpose in terms of the Eskom roadmap, and the fact that this was a decision taken by the country that we are going to go the route of restructuring and redesigning the market system in South Africa. We can go to the next one, Ari. Okay, BUSA, IEUG, and the Energy Council. This comment is specifically on section 4.1b, Roman numeral 1, which states that the regulator may mediate and or arbitrate disputes between generators, transmitter, distributor, traders, and transmission system operator, and any other licensee or customers or end users. We have noted the comment, but not necessarily in support, because the regulator must mediate and arbitrate between the generator and or private generators, while private bilateral agreements between between willing buyers and sellers. So that is the response or position from the department. The next comment is the 2022 Amendment Bill includes Section 9.1 Cap A, which is not included in the 2023 bill. The comment has been noted, but however not supported. It does not speak to the 2023 bill and has no bearing on the bill. However, the interpretation and clarity which is sought is provided, apologies for the typo, under Schedule 2 exemption item 2, which entrenches the exemption of certain generation facilities from licensing. So we just made a reference to Schedule 2 to ERA in this regard. Section 10, subsection 2G. The comment is that this section is in the ERA was not included in 2022 amendment bill and has been reinstated. The recommendation, it should be made clear that this applies to public procurement programs and does not apply to private projects. So what we looked at is comments that they had given to the 2022 bill. BOSA's response in the bill proposed the removal of the section, objected to the deletion of 10(2)G on the basis that it removed from the principal, it was removed from the Principal Act. It removed the power of the minister to grant deviations from the IRP. A private sector generator developing a generation facility for the purchase of electricity by a private sector customer should not require ministerial determination, and therefore the ability of minister to grant deviations from the IRP under 10(2)G remains essential. The power to issue such definitions should not be linked only to ministerial determinations. So we are proposing that we keep the formulation of the text as it is. Section 21, 1 cap A and 1 cap B were included in 2022 and have not been included in the 2023 amendment bill. And the proposal is that these should be reinstated as they are seen as clauses that would encourage generation investments. We have noted this comment, but not in support. The reinstatement of section 21, 1A and 1B will contravene the provision of no person can trade without a license, and currently all traders are licensed. So anything that is not licensed, we believe is sufficiently covered under Schedule 2, which is the registration process. In any event, the cap has been lifted anyway. So we're proposing that we don't reinstate this one. The Energy Council of South Africa, on section 14, specifically, the comment was that we believe that pricing does not need to be regulated in trading between willing buyers and sellers. Therefore, the definition must include private generators and or traders to avoid conflict. Comment has been noted and supported. The principle is that prices are not regulated in trading between willing buyers and sellers. Moving on to comments that we received from Eskom. This is one section where they feel 10(2)G that it has not been amended. The RP is defined as an indicative plan. Requiring this evidence of compliance to an indicative plan may raise serious challenges for the functioning of a competitive market. In the main, there's the comment or concern from Eskom. This comment has been noted, but not necessarily supported, because we believe ERA does not amend this section. In a competitive market, the provisions of IRP compliance will be dealt with under the principles of security of supply, orderly development, and the energy mix. So we propose that we retain the formulation as it is again. Moving on to 21.4 cap D. The section may give an impression that charges for reserved capacity will follow market principles, whereas on the contrary, these charges will be subject to NERSA regulation. Transmission and distribution licenses shall procure the energy they may use to cover energy losses and reserve capacity in the system. on the basis of non-discriminatory market-based procedures. This comment has been noted. Our position is that third-party access to the transmission and distribution power system must be based on published tariffs applicable to all eligible and applied objectively without discriminating between system users. And these charges will not be subjected to NERSA regulations. So we're proposing again that we leave the formulation as it currently is. Okay, these are individuals that submitted comments in their individual capacity. The first one is in relation to 10D3. All information must be open to the public to ensure transparency of electricity purchase agreements and applications submitted. The comment has been noted but not supported. Based on private purchase agreement and application submitted where such application contains commercially sensitive information. Such information may be withheld from being made publicly available. That's just a pure legal matter. These transactions are legal in nature, and we cannot in this bill insert such clauses to force in that legal transactions be made public or legal agreements. 15 subsection 1 cap A, customers should not bear the brunt of increased electricity tariffs to fund the Eskom grid expansion. The comment has been noted. I think it's just, there is no way in the bill where we are voting for that, but we have noted the comment. All IPPs, independent power producers must abide by tariffs agreed upon in application to NERSA in agreement with Eskom. This may not be deviated from or artificially increased. The comment has been noted and supported. And this has to do really mainly with the affordability of the end user. Section 26, subsection 4, objection. NERSA allowed Johan Rupert of Remgro Energy Exchange to get electricity trading license with the whole application form. The comment is noted. The comment does not really speak to any specific provision of the bill, but rather it sounds like it's speaking to a separate matter. So we just note the comment. Section 9, all traders should be licensed. There should be no exemptions relating to trading, hence the proposed revision to exclude activities relating to trading. The comment provided herein is supported. All traders must be licensed. So we support this recommendation. And move to the next one, Ari. On section 10B, there's a comment that although there are no changes to the applicable ERA provision, this needs to be aligned to the terminology used in the tariff methodology and the provisions of section 15, subsection 1C of the ERA bill. The recommendation is noted and supported. And then there is a recommendation there in terms of the proposed insertion, and we take that insertion. And moving on to 16.2 to 18.2, while the regulator may be better placed to deal with issues expediently, the regulator will, however, gain more functionality as a player and a referee. The regulator issues licenses, makes the rules, set prices, and revoke licenses. The regulator even determines the amount for the penalty, manages arbitrations, The recommendation is that there should be an element of separation of functions in these cases to bring about greater objectivity. This comment is noted but not necessarily supported, and this is on the basis of the considerations made in light of the process currently and that NESA follows, because they follow a similar process with the Competition Commission, which does bring objectivity into the process. On section 19, this comment is on the period of a license. A 15-year period will not satisfy most investment appetites. Either a 20-year or longer would be more appropriate. Further investment assets within generation and transmission generally have a useful life longer than 15 years. The comment provided is accepted to align to the lifespan of the underlying assets, either as a 20-year or longer. Again, this is in terms of benchmarking standard practice. That is why most PPAs currently, even with between Eskom and IPPs, are entered into for a 20-year period, just to attract investments and allow investors to recoup their investments. Section 2, tab A. Again, it's a comment from Natural Justice and Center for Environmental Rights, where they're saying the bill excludes the application of the Act to any generation capacity of 100 kilowatt or less, while this threshold forms the basis for embedded generation. This low threshold limits the growth of distributed energy resources and community-based renewable energy initiatives and will slow the clean energy transition. International good practice indicates that 1 megawatt of capacity is the common limit for embedded generation. The comment is noted, but not necessarily supported. The bill excludes the application of the Act to any generation capacity of 100 kilowatts or less, because most of the system serves as backup generators for residential consumption. So we are proposing that we keep the formulation. 9, 10, and 11. The wording indicates that adherence to the ERA is deemed necessary. However, instead of compliance with the provisions of the ERA, the proposed amendment indicates that compliance with technical codes that may be applicable from time to time and regulatory requirement is necessary. The comment is noted, but not supported, in that the proposed amendment indicates that compliance with technical codes that may be applicable from time to time and regulatory requirements is necessary for the different applications and connection envisaged in the bill implementation. This is Chair, another area where we were saying we have to elaborate more as well on in the regulations once the bill is promulgated into law, so that we provide that detailed clarity and the usefulness of the section. Bill introduces a new definition of the IRP. However, it no longer proposes the addition of a new section to deal with its revision and development. This is concerning because without this regulated instruction in terms of the considerations to be contained in the IRP, the minister has seemingly unfettered discretion as to its content. And the recommendation is that the IRP as an access planning document should fall within and be aligned with the IEP as provided for in the National Energy Act. These are general comments provided, and we have noted them. These comments do not necessarily speak to the bill, but however, we do agree that the IRP forms part of the IEP, because the IEP is the integrated energy plan. It looks at energy sources broadly, from electricity to liquid fuels, gas, and other sources. A comment on section 9. shifts the onus of the publication requirement on NERSA by stating that NERSA must direct the applicant to make the publication. No remedy exists against NERSA if it fails to provide such direction, or against the applicant if it does not abide by such a direction. This is seen as problematic. The thinking is that it lacks the specificity, currently leading to practices by NERSA and the applicants which are inconsistent with the Promotion of Administrative Justice Act and the PAIA regulation. These are general comments which we have noted and supported. However, these comments do not address any specific issues in relating to the bill or the regulation, but rather processes of NERSA. However, NERSA's powers as to when and how it may agree that such information may be considered as confidential to be clearly defined in line with PAIA and PAJA objectives. In fact, this is quite important as well because most of the cases that are taken on review are mainly on the basis of PAJA, where the saying promotion of administrative justice was not followed sufficiently. And again, this is another area where we will go into details in the regulations, because that's where you even stipulate the timelines for publications and comments and adverts to the end of the process during a licensing process. Section 15(1)(a). There is a recommendation that ERA needs to take into account climate change obligations and implications, and the section should be amended accordingly under a climate policy agenda. The promotion of renewable energy should be a much broader responsibility of the regulator. The comment has been noted, but cannot be addressed in this specific provision of the bill. It has no bearing on the entire bill at all. It is, we felt, an issue around climate change and just energy transition, which is not necessarily to be covered in this particular bill. We can go to the next one, Ali. Thank you. Section 21, the amendment to the section introduces non-discriminatory open access obligations to allow third parties to use the grid services in an equal, transparent, and efficient manner. Then the recommendation is that, however, international good practice would also introduce proactive policies to grant preferential grid access to renewable energy generation. And these policies could include lower transmission or interconnection tariffs for renewable energy. And we are saying we have noted this comment, but again, it's one of those general or generic comments that does not necessarily address the regulatory nature of this particular specific instrument. Comments from NOMSA 315.2. To promote renewable energy must be changed to low carbon emission generation sources. And then they further go on to say significant consultation and participation has not taken place prior to public hearings of this bill. Case law has set precedent, and merely informing affected parties does not constitute a consultation. The proposed amendment to include promote renewable energy is supported, and the comments regarding public consultation, we just note that comment. Then there's another comment on section 10. The National Energy Regulation Act provides that every decision of the energy regulator must be consistent with public interest. 15(1)(a) above undermines this mandate given the energy regulator, as it contradicts the provision that a decision must be in the public interest. We have noted this comment, the energy regulator must allow for a reasonable return commensurate with the risk of the licensed activity. So we are proposing that the formulation be kept as it is currently in the draft bill. On section 15 in this clause, NERSA responsibilities to set and approve tariffs which previously applied to Eskom have been extended to IPPs. The comment has been noted, but it does not necessarily speak to this provision. Yeah, it's just a comment that we note. On section 34B, 5C, Roman numeral 1, the Central Purchasing Agency will be the buyer for existing IPPs, power purchase agreements, and new power purchase agreements, which contradicts the stated intention of the bill to facilitate a market competition. And there's a recommendation that the Central Purchasing Agency must conclude power purchase agreements with each Eskom generator to cover capacity payments and ancillary services. The comment provided is noted. The bill does provide that the Central Purchasing Agency must conclude power purchase agreements with each Eskom generator to cover capacity payment and ancillary services. So we feel this one has been sufficiently addressed, and we propose keeping the formulation as it is. The next one is on section 4. That the regulator should be allowed to mediate but not play a role in arbitration, that they have any reference regarding any regulatory aspects of the market transaction. And the proposal was that we delete such reference. We have noted this. Sorry, Ari, you moved too quickly for me. We have noted this comment, but we are providing clarity that the mediation and arbitration by the regulator is related to regulated transactions, and we are proposing that the formulation be retained. Section 9, this is applicable to public procurement process / program, but not to what is envisaged under Schedule 2, clearly define that this is not required for private sector projects. And we're just confirming that it is applicable to public procurement and not envisaged under Schedule 2. On section 14, NERSA's powers to make conditions to licenses should be limited to exclude these envisaged market transactions, as this would defeat the original purpose of the competitive market. We have noted the comment, and we support that the conditions to licenses are limited to exclude the envisaged market transaction. So we believe that the formulation does provide the clarity being sought on this comment. On third-party access, defined in section 20 of the bill, is they're saying this is the core to the establishment of the market and market transactions. We believe an extensive definition of this is warranted with references to both license stipulation and the envisaged market code and grid code, and they're recommending an enhancement. The comment is noted and supported to provide a definition in license stipulation. So that one is supported. We will formulate an insertion or a text for that. Section 20, subsection 1 cap A and 1 cap B were included in the 2022 amendment bill, but have not been included in the 2023. And we do regard these duties as important. For clarity, please reinstate. The comment is noted but not supported. 21(1)(a) and 1(b) suggested that generation licensee shall be entitled to sell the electricity produced by the generator facility to which its license relates without holding a trading license, and this is sufficiently as well covered under Schedule 2. So we are proposing retaining the formulation in this regard. On Section 10, subsection 2G, the current bill worryingly restores the requirement that an application for a license must show evidence of compliance with any IRP applicable at that point in time to seek ministerial approval for any deviation. And there is a strong recommendation for this requirement to be removed. We have noted this comment, but we are not necessarily in support of it, in that for all regulated licenses, this is a requirement that an application for a license must show evidence of compliance with any IRP applicable at that point in time or seek ministerial approval for any deviation. In the market, this requirement is not applicable to market participants or transactions. 14(1)G, with the growing private producers within a liberalized market, we propose that the revenues of prospective traders are not regulated by the regulator. The comment has been noted, and the bill does not provide for any revenues to be regulated. 35C, we would argue that a more detailed account of the principles under which the NTC will operate on an independent basis from Eskom should be included in the bill, since this is bound to be an area of contestation and potential bureaucratic confusion, not least because the transmission system that is being rendered independently is arguably the most stable and predictably profitable component of the current Eskom asset configuration. The comment has been noted, but not supported, in that the National Transmission Company will operate independent from Eskom, is not government policy and not part of the Eskom roadmap in the transition. So we are proposing that again, the formulation be kept, or the text be kept as it is in this regard. Saweya, we welcome the removal of the reference to construction in the categories of licenses that the regulator must consider and issue. The feeling was that it's not clear how the regulator will set tariffs and what methodology it will use. And we're asked to provide clarity. And we are noting this comment. The regulator will set the tariff for regulated licenses and not market transactions as defined in bilateral transactions, because those are transactions between private parties. We can move to the next one.
Which one, ma'am?
Okay.
We finished up with section 4.
See. Yes, then the next one is section 8. Yeah, right at the, it starts at the top of this page. Yes, sorry about that. So on section 8, there's a comment that you are of the view that consultation with the regulator and the general public is sufficient for the minister to exercise this discretionary power. Specific mention of the advisory forum is an additional layer, which is likely to lead to delays or introduce vested interests. The electricity regulatory framework must be in the public interest, so the proposal is the that there be a deletion of the advisory forum. We have noted this comment, but are not necessarily in support of it, in that the mentioning of the advisory forum could be viewed as an additional layer, which is likely to cause a delay, but is necessary to ensure that processes are managed sufficiently and there is sufficient level of authority and eyes at different levels that view these transactions. On section 10, we note that the 2023 amendment version has omitted the 2022 amendment. This reinstates the requirement for generation license applications to provide compliance with any integrated resource plan and provide reasons for deviation for the approval of the minister. The view is that this should not be applicable to private generators entering into private or offtake agreements. The comment is noted and supported. It should not be applicable to private generators. And I think we did speak to this somewhere in the comments. On section 11, the original act provided that the regulator may require that an applicant publishes a notice of the application. The proposed amendment uses the word must, which makes it obligatory for the application to advertise the application. So we have noted this comment, Honorable Chair, and we are in support to provide for a case-by-case instances and for the regulator to exercise its discretion having regard to scale and size of the proposed project, location, and its impact on the public interest. Okay, that one is straightforward, welcoming the reduction of the number of days from 120 to 60. This is us trying to improve the ease of doing business in South Africa. That is noted and welcomed. On the next one, section 14, subsection 1Y. The condition includes subcontracting of the maintenance of transmission and distribution facilities. We are of the view that these terms are included in the definition sections of the bill. Further welcome the retainment of paragraph Y in the Principal Act. Again, this one is just for us to note, and we agree with the comment. Another one, which 15D is welcome. However, there is a recommendation that these provisions, specifically 15(1) cap A and 1 cap B, exclude market transactions as defined. The comment is noted and supported to exclude market transactions as defined. I think there was also a similar comment in the above, in the sections above. On section 17A, we're of the view that the application for revocation or suspension of registration on application by a third party must be subjected to the highest level of reason and assessment. The comment is noted and supported. It's all about the integrity of the system and the function of the system. It is further, this one is on section 11. It is further noted that the proposed amendment bill seeks to amend section 11, amends section 11(1) to require publication of a notice of the license application in at least 2 official languages for a period of 30 days in newspapers other than media, as the regulator may specify. Circulating in the area of the proposed activity, the proposal is acceptable. It has been standard practice even previously. Okay. Section 34A and Section 34B. We would suggest that the department adds further clarification on the scope of the Transmission System Operators Authority, as well as with respect to the transitional arrangements phasing from the temporary National Transmission Company to a fully fledged independent transmission system operator. Although this is not noted in clause 28 in the Memorandum of Objects of the Electricity Regulation Amendment Bill, which refers to a strategy document by the Department of Public Enterprises, we recommend a clearer stating in the bill itself. The following clarification will be provided by in the instrument, which will establish the National Transmission Company into a fully fledged independent TSO. Again, this one is on the details in relation, the next row is in relation to the details on the TSO and the functioning of the market. The comments have been noted and supported to include transmission expansion plan, forecasting and dispatch scheduling. These are all within the functions of the TSO. Section 34B to B. This in effect makes the TSO responsible for what is currently the transmission development plan. The comment has been noted. The bill provides the principles in which the transitioning and development of transmission development plan will be handled. So we believe this has been sufficiently covered in the bill. On Section 34, matters pertaining to development of transmission infrastructure should be removed and delegated to the transmission licensee. The comment is noted. The transmission licensee will be tasked to develop the transmission infrastructure. On 34A, 34 and 34B, there's a suggestion that the functions of the TSO as a market operator be fully detailed in a separate document that will give details on the various participants in the envisaged trading platform. The function of the market operator will be detailed in the market model. Again, it will also be covered in the founding legislation for the creation of the TSO, as well as its associated regulations. Green connection on Section 34 determination. A question is posed: exactly what is meant by optimal supply of electricity, failure of the market, emergency and national interest is not defined in the bill. The comments have been noted and the definitions will be provided, so we will be working on the formulation. Then there is also a concern that the bill also seeks to empower the minister to make critical decisions relating to additional electricity and new electricity generation capacity and related infrastructure without requiring concurrence of NERSA, as is currently the case. The comments provided have been noted. These comments do not necessarily address a specific clause in the bill, and so we will just note them, but we looked at the formulation as it currently is, and we're proposing that we keep the formulation, as well as reference to nationally determined contributions, which is something to do with the climate change bill, not necessarily this particular bill. Similarly, with reference to the Presidential Climate Change Commission. The next one is no criteria are specified. No criteria is specified for what may constitute such an emergency or what may be in the interest. It is also noted that while the minister is obliged to invite the public for comments, prior to deviating from the IRP and the TDP. Section 8 empowers the minister not to invite public comments if it is reasonable and justifiable in the circumstances. There's a recommendation that 34.6 be revised to specify a criteria of what may constitute an emergency. The comment is provided has been noted. And what may constitute an emergency, again, has been clarified in the bill, but further details will go into the regulations, because the regulations to the bill is where we provide clarity on what is contained in the body of the legislation. 34.3 okay, yeah, it's still the same. Recommend should be vision for the conducting of the electricity transmission infrastructure, but not necessarily support my internet. Am I still audible, Chair?
To me, yes.
He left.
Continue.
He's out of the meeting.
He's back in, Chair.
Continue, Ms. Mwabe.
Apologies, Honorable Chair. I got kicked out. Where was I? The Green Connection submits that the proposed section 34.3 should be revised to include, I'm okay, Ari, I'm on page 32 at the top. Should include the mandatory requirement for the inclusion of provisions for conducting the procurement process. We were saying we are not necessarily in support, as there is no need to include the mandatory requirement for the provisions for conducting for the procurement process or for the establishment of the electricity transmission infrastructure. Processes for the development of the IRP will apply to the electricity transmission development. There is therefore no need for the bill to articulate a different process. Section 34.10, the meaning of bound by is not defined in either the existing ERA or the bill, resulting in uncertainty as to what the term means. The comment has been noted, but not supported, in that the regulator, in exercising its discretion as a regulator, is bound by any determination made by the minister. The insertion of the definition bound by is supported to provide clarity. Apologies, Chair. I think there's an error there on the first sentence in our response. On the, yes, I'm on that last row. The provision does not qualify the power to issue such licenses or registration certificates in the absence of a ministerial determination, for example, by stipulating that the regulator must have regard to the content of the IRP or TDP. A requirement imposed on minister by section 34.6A when making determinations. The thinking here is that this provision potentially grants unlimited power to the regulator to issue licenses for electricity generation capacity not contemplated in the IRP. The comment has been noted and supported in that the regulator may issue a license or registration certificate for listed activities as per section 4.1a in the absence of a section 34.1 determination by considering issues relating to climate change considerations, least cost and affordability amongst others. On that second row, it is of concern that to the green connection that these proposed amendments relating to energy infrastructure projects are being proposed in the absence of an IEP developed subject to public consultation and annually reviewed by Minister in terms of ERA. So we have noted this comment. The maybe one point to make on this in the response is that the department has initiated a process since we brought into effect section 6 of the National Energy Act. We are now in the process of developing the integrated energy plan. And so this will be addressed in the IEP. Western Cape government on section 34. The approach introduced by the recent amendments to Schedule 2 of the Act, which has subsequently enabled rapid development of electricity generation projects for the private sector without the need for a determination or licensing has reference. The Section 34 determination process in its current form as currently applied is not in line with the liberalization of the energy market and is not supported. The comment is noted. I think also we have moved to ensure that there are alignments with the amended Schedule 2 in the Act, because Schedule 2 does enable, as acknowledged already in this comment. Okay. Alternative Information and Development Center. Unbundling Eskom and establishing the NTCSA will allow for increased level of private sector energy generation. This will have a direct cost in terms of the purchase of energy from private generators. I won't read the whole thing, Chair, but this one is more around the costs and the tariffs. And then later on, there is, I think, paragraph number 4 on this left column talks to decarbonization. It is recognized that decarbonization is not one of the main objectives of the bill. That said, given the increasingly severe impact of extreme weather and the trade disadvantages imposed by carbon taxes such as CBAM, the impact of this bill on South Africa's decarbonization project ought to be discussed. Our comment is general on these points, that these issues are not issues to be addressed in this bill, because the nature of this bill is such that it is a regulatory instrument to regulate licensing and tariffs processes in relation to tariffs and price setting and the operation of the market, as it were. So we note the comment. This is a comment from an individual, Mr. Hugo Kruger. His sentiment is that unbundling Eskom is going to cause more problems. We note the comment, but as indicated previously in some of the comments above, that this is a decision the country has taken. We are merely giving effect to those decisions to redesign and reconfigure the utility and create an open market. Natural Justice and Center for Environmental Rights. They're saying the bill falls short in several important areas, including the promotion of distributed generation energy storage, and transparency and disclosure requirements for energy planning and procurement process. We are fundamentally opposed to any mechanisms which enable or have an effect of enabling effective privatization of electricity. We note the comments and we thought that some of the general comments made here have been addressed. However, most of them, in fact, the larger part of it is generic and does not necessarily address any specific section of this bill, but it's just their view. They are expressing their view. And on general comments from NOMSA, these comments again do not address specific provisions in the bill and have no bearing on the provisions of the bill, but it's rather their sentiments in terms of how they view the entire electricity industry reconfiguration. It is understood that under competition, the vertically integrated utility gives way to a number of different and more specialized market players, including generation, transmission, and distribution. However, the bill does not make any determination on the role of local government. Just to be specific on that, that last line on the right column, the relevant local government municipal legislation does provide the role and authority of municipalities, and we thought this bill does not necessarily have to speak to that. Again, this one speaks to the constitutional mandate to enable universal access to affordable electricity to all South Africans, regardless of their location. Then they make, should the Electricity Regulation Amendment Bill be enacted, rural and scattered areas in South Africa will be unelectrified. The Principal Act and the bill provide the regulatory tool for the electricity industry. Again, this is not an issue to be addressed necessarily here, but there are programs where this is dealt with, like the off-grid program or the non-grid program that the department continues to roll out. From Operation Vulindlela, there's a comment that the bill should provide clarity on the legal and institutional form of the TSO and impose clear requirements for non-discrimination between access seekers to the transmission network. We note the comment and we agree that the legal and institutional form of the TSO must be articulated clearly, but this will not be done in this instrument, but rather in the TSO founding legislation. These are two individuals that made comments. Promulgation should be put on hold. ERA bill's promulgation should be put on hold until we understand the costs and risks of the transition and put the building blocks in place for this to occur in a sustainable manner. Without going through that lengthy comment there, we note or response, we note this, and these comments do not necessarily address specific areas in the bill, but it's just a sentiment to say there must be risk assessments and costing of the transition, which I guess is outside of the scope of this bill. There's also comments on the electricity and pricing policy. The electricity pricing policy has been reviewed and has been taken through consultations through the network structures, and the process has been completed. A report is expected to be submitted, the final network report, and from there then we will continue with the approval process of the the pricing policy, and the policy does take care of the free basic electricity or covering the marginalized and the poor in society. Again, individuals, the objection that the bill will worsen poverty is misplaced. The bundling of Eskom and the creation of a separate TSO is not privatization. Okay, we note here this generally supports the purpose of this establishment of the TSO in the bill. We can move to the next one, Ari. This one came from Rural Action for Climate Resilience Project, general comments. We urge the inclusion of more active regulatory mechanisms for protection of the poor and vulnerable against increased cost of electricity, given that NERSA will no longer be regulating prices, but can set tariffs. We note that it's not addressing a specific area or clause in the bill, but rather a sentiment on the concerns around cost of electricity to the end user. The bill creates uncertainty for energy planning given the removal of Section 32A in the bill regarding the minister's responsibility to develop an IRP and on the process to be undertaken in doing so. The comment provided herein has been noted. However, the bill does allow the minister to develop and revise the IRP without necessarily providing details on the level of or on the process to be followed, as well as the IRP, the fact that the IRP will be part of the integrated energy plan at the end of the day. And I think we did make mention of this in the earlier sections. Again, Ms. Sasha Bartlett, an individual. Ari, we can go to the next one. Just a comment that electricity is too expensive. We note that comment. As well as, I think the comment was similar from SAF 2. Can we move to the SAF here? The bill, in our opinion, lacks a dedicated monitoring and compliance chapter. We strongly recommend such a chapter to be added. The sentiment or the view is that the bill ignores regional opportunities such as the SADC African Power Pool. We do understand that the TSO will have an international trading section or division, but much more enablement needs to be added. A comment is noted and supported in terms of procurement of new energy, and transmission will continue as a trading arm and to form part of the SAPP. So we welcome that comment. Another one from Cecil. We urge the department in finalizing the text of the Prospective Act to ensure regulatory efficiency remains a guiding principle. The principle of registration of generation as opposed to licensing, for example, as per the exemptions provided under the amendments to Schedule 2 of the current Act should be maintained, for example. Yes, and we note that and we support that. That is the whole idea. The bill creates the prospects for private participation in the transmission system by omission, in that it does not require that a transmission licensee be a public entity. We note this, but we do not necessarily agree because that is not what is being proposed or purported in the bill. Green connection. The removal of the provisions contained in Section 32A of the 2022 bill is even more alarming and results in more uncertainty on the obligation to develop and revise the IRP. and on the process to be taken in doing so. So there is a recommendation that the proposed bill should retain the requirements set out in section 32A to include the methodology to be used by minister in compiling the IRP and specify relevant considerations that should be taken into account. And they also go on further to make reference to the integrated energy plan. We are noting this, but I think there was again a similar comment above to say the bill still does recognize the importance of the IRP, but details do not necessarily have to be contained in this piece of legislation given its nature and its intended purpose. Its intended purpose is not to provide clarity on such processes, such as the development of the IRP, but to regulate the electricity industry. We can go to the next one, Ari. There is currently uncertainty about South Africa's overall energy vision, policy, and strategy for the energy sector. The recommendation is that certainty should be provided through confirming and or establishing the energy or energy reform vision, policies, and plans. This is more a generic comment, but we do believe that the amendment, for example, of Schedule 2 to this to ERA, as well as the amendment of the ERA with this bill being submitted to Parliament, is some of the initiatives to provide a vision and policy guidance and strategy going forward for the energy sector. So we do believe that this is one of those instruments where we're providing that vision. The minister has not published the recent energy or electricity policy. The last overarching energy policy was published in 1998, the white paper. Again, these are generic comments. What we did, if I may just comment on this quickly, when we're initiating the process, we did look at the 1998 paper. And in actual fact, we always believe that that white paper is still relevant. Everything that we are doing now in the electricity space and energy broadly is actually contained in that white paper. The unbundling of Eskom was foreseen back then, was envisioned, it's there in the white paper. The IEP was envisioned in the white paper, so we believe that the white paper in its current form is very much still relevant. Does not deal with changes anticipated in electricity distribution, nor does the amendment bill provide further clarity on the role of local governments beyond October 2020. It is proposed that further amendments be made to the bill to address changes required in the electricity distribution. It is further proposed that the bill clarifies the role of local government. I think we did make this comment earlier on to say we will not necessarily go into those details in this bill, but the roles are clarified and they flow from the Constitution. Municipalities are treated as bystanders in the reform, and their role in the amendment bill appears to be constrained to the electricity distribution industry and not as participants in the market structure. We note the comment, but we don't necessarily agree with the comment because we do, through Schedule 2, recognize that some municipalities are generators already, some will be in future, for example, and that they are in the distribution space. Ari, can we move to, I think we are at the end here. That was just the recommendation that is made based on this comment. Thank you so much, DG. We are at the end of the table. Thank you,
Did
Honorable
you
Chair.
settle? DG, are you still part of us?
Yes, Chairperson. Apologies. I'm still here.
Your DG says it's done.
Yes, apologies, Chair. Yes, that's the end of the presentation. My apologies. Someone had walked in here and took my attention away from the meeting. Yes, that's the end of the presentation, Chairperson. I hand back to you.
Okay, thank you. I know it's a long day. It's one of the challenges we accepted. Honorable members, we do have you have given the department an opportunity to respond on the written submissions and the oral submissions. Can I then check honorable members who want to maybe get questions of clarity, if there are any? Going one. And then I think I am here. Going two. Going three. Okay, no comment. Thank you, DG.
Sisayofunda sihlalo uDisemba ingqondo ayini. Sisayofunda.
I didn't want to say so. At least if you say it yourselves, that's okay. No. I think what is good, honorable members, for me, is that the department has done it a little bit well. My only concern, maybe not a concern, is just to seek clarity, the MRE, on two issues that we are battling with here. And I must ask them because we are here. They are not related to the presentation, because I think the presentation helps and guides members that on this comment, this is what is it. Whether we agree with your interventions is something else. We can take what we want to take, leave what we don't want to leave. I just need, maybe you can help us on this clarity, because I raised it in the presentation. And I didn't want to raise it in the morning. Two things have happened. I think the DG must help us in the absence of the executive. It might be handy for you, Ntokozo and the rest. And I'm raising this thing because I know, for instance, with what you call Operation Vulindlela, you did not necessarily disagree with them. But there is a different approach or different formulation. Let me give an example. On the issue that you were raising, once you agree with them, your response was that if I'm correct, what they are raising is on the founding legislation of the TSO. Now they are raising an issue. Probably, I'm saying you are in agreement, but for you it is contained here. Here is my dilemma that I think, especially from the DG, must happen. I'm very much concerned, one, and I'm straightforward, that, for instance, NERSA falls directly under the MRE. Public enterprise contains what I would call ESCOM. And I'm not saying they should not come, but my worry, because they said it in this meeting, for instance, if I'm not mistaken, was it NNR or yeah, I think it was NNR, that when they wanted to, they raised some of the issues. In as much as the department did not have problems with them, they said, the department said, no, go to you can make your presentations in the portfolio committee. Now, I'm putting this thing because, I'm raising this thing because my understanding is that in the past two bills or so that we dealt with before, that had passed, we understood that part of the balance or the base of the legislation or its amendments is some of the entities that are central. Don't you think, I'm asking this question because I did ask that, don't you think there is a risk that one day this committee will find itself subjected to where government entities and at times departments have got contrary views, and now the committee must be used as a platform to adjudicate or to be contested to take those views? And what is the purpose of all these entire executive processes if there are differences? Put it the other way around. Do you really think that at some point we must arrive at a situation where we ask what is the reality? For instance, whether it's the disagreement what you are presenting in the committee. I think if you can help clarify this thing, because I'm of the view that in future, we will end up dealing with things that are supposed to be things that are ironed out at an executive process level. That's my first thing. But my second thing, which is a concern, is that which one should we take in regard to this? The last thing that I think I want also to get clarity on, I think I didn't see it. My apology if it was contained. My apology. Maybe it skipped me. Outer had raised an issue, and I didn't see it here. An issue with regards to what is this thing? It's not the powers. Oh, the issue that says it would be nice that when the legislation is being amended, the original part of the legislation is also provided, and therefore within that, the areas that are being legislated are marked or underlined. What is the take of the department for that? Because most of them, they say they do not understand, they just get that section so and so is being amended and this, and that's what is contained. But in terms of the overall totality of the bill, and when questions are being asked, reference at times is made to the original bill that they don't have in front of them. What is the take of the department on that? I think for me, that's why I said it's not necessarily on the presentation, it's on the process, which I think is becoming problematic. My first point where I was raising was also informed by the fact that I'm of the view that the process of public consultation, it is meant for people who don't have platforms where they can raise these issues. Now, my concern on the first matter is that what is supposed to be a process of public participation gets conflicted by the fact that executive authority processes are also overlooked, and they, one in inverted commas, overcrowd the process of the public hearings. As I said now, we are sitting with almost 4 or 5 entities, or including departments and the presidents, through Operation Vulindlela, that are participating in a process which one might say it is meant for public consultation. Then can you answer those two if you want? But I don't want to prescribe DG, but I think it will be more important if it is looked at by the DG.
No, thank you, Chairperson. Thank you. Chairperson, with regard to the first point that you raised around obviously and specifically departments or entities coming during the parliamentary process to make inputs. One can start by first saying that there is a process that we undertake before we obviously end up getting the approvals to table the bills in Parliament. And that process includes first the drafting in the department. We go to Cabinet, we ask Cabinet to publish Before we even actually go to cabinet, we go through the cluster system, the cabinet cluster system, including the DG's cluster, to present to the various departments, and then we go to cabinet, and obviously the bill gets published out for public comments. And then once we have taken into account public comments, we go back to cabinet to be allowed to go to parliament through the same process. So insofar as departments are concerned, they get 2 opportunities before the bill lands in parliament for them to obviously comment. And it's 2 opportunities if you count the stages that the bill goes through. It's the DG's cluster, it's the cabinet committee, and it's the cabinet itself. You will notice that it's twice, but you can multiply by 3. There are 6 almost interactions with the bill, where if there are issues that people feel have not been addressed, can be addressed at that level. And from where we're sitting, that's the process that all departments undertake to get to this point. But what happens is that in some instances, we have had situations where after the facts, when the bill is already passed, we get departments that come to us with comments saying they have these comments and they still feel that these are important comments. And I take it those are those departments then that decide, for various reasons, they decide to obviously try and utilize the opportunity that's created by this particular process that you are running. So from our side, and I can say there are those 6 opportunities where differences can be engaged on and at different levels. And it's actually in some instances it's more, because when the bill is out for public consultations, we sometimes have bilateral meetings with the various departments or even agencies to engage on their comments. And Chair, so the other reason why people might come your way is that for various reasons they may not be happy with how we would have considered their input, or even happy with the reasons we've provided, and they probably see this as an opportunity to convince, obviously, yourselves and everybody else that the view that they have on a certain matter is a superior view to probably, or is a better thing to do than what we have put in front of you. So basically, that's how I believe we find ourselves in some instances in a situation where we are. With regard to the second question, I think it was more a drafting issue. And I think DG Nqabi can chip in on this one, but I'm aware that on the actual bill that we issue, there is a method that is used to track changes in terms of what we are deleting, what we're adding. So my view is that the full bill with the amendments is generally available, showing those changes. DG Nqabi, you can come in on this one and clarify further. Thanks, Chair. With your permission, DG Nqabi can add on the second response.
Okay. Thank you, DG. Thank you, Honorable Chair and members. Yes, firstly, DG, I had the question to be 2-pronged. One, it really is a drafting issue, and as we update and make changes as we draft, we share, we consult, we engage thoroughly. But also on the specific point, Chair, which I had you to be making around the public consultation process, you are correct, Chair. The whole point with the public consultation process is for stakeholders to use that time to make inputs. And I will link it back to the first question in the part that DG explained. When we take the bill, for example, to cluster, this is now at cluster, your Operation Vulindlela, whoever, all the departments are represented there. We share the actual draft bill with them. So they have time at that point to look at the bill and give us comprehensive comments. As the bill goes to cabinet, they still have an opportunity. Once we put it out for public comments, and what we do, we don't just, once we've published, we don't just sit and wait to receive written comments. We still reach out and have workshops and meetings with some of the stakeholders. Some would reach out to us and say, we have comments, but we want to discuss these comments with you and submit them in writing, and we do allow that. But additionally, we even allow for extensions on the consultation period, because you would find some stakeholders would write to us 2 days before the closing date and request an extension, and we generally do grant the extension because we want to avoid a situation where somebody comes back and says they did not have sufficient time. So yes, your understanding is correct, Chair. I think we just need to close the loop, especially with government departments as well as SOEs, especially more so with our SOEs, because they do form part of the drafting team. We always make sure we invite them to be with us in the drafting team, so they have access and view and understanding of the bill right from the inception. Chair, by the time we get to public consultation, they would have been actually part of the process all the way. Thank you, DG. Thank you, Honorable Chair.
I hand back to you, Chairperson.
Okay, no, thank you, DG. Thank you, Ms. Mwabe. I've now noted, I got your answers, and I think your last point, Ms. Mwabe, is very truthful, and I like it when it is truthful. Now we know, and I'm sure honorable members, this is going to be one of the issues at the end of the day we may have to express our views on, whilst we are dealt with the substantive matters of the contents and substantive matters of the legislation. On that note, honorable members, I think we have arrived. Is there any other matter that I'm leaving at the conclusion of our today's session? Is there any matter that I'm leaving? Ari and Ayanda?
Okay.
I don't hear you, Ari.
Nothing from my side, Chair.
Okay,
Nothing from my side, Chair.
On that note, honorable members, thank you very much. You may underestimate, it's not something easy. Honorable Malinga, make it as a joke, but I always say, as a chair, I take pride on the fact that members, when we are called for duty, we are prepared to make these sacrifices. Parliament had closed last week, but with your dedication, you continue to participate. I'm really, really very appreciative, and with your support, otherwise we could not have had this meeting if honorable members were not present. I wish to thank you for making such good gestures and commitment to the cause. Thank you very much. Last week you were here Thursday and Friday, and we are here today. But I think I must say we have now finalized everything with regards to the bills, with regards to the department's comments, but we have not finalized the work of the committee on the bills. We have just finalized what relates to the comments by the department or responses. That also means today we have exhausted the program of today and tomorrow. So tomorrow you are free until on the dates that Ayanda and Ari are calling us back on duty. Thank you very much, honorable members. Thank you for the department for your participation in today's session, as well as to the committee staff, including Parliamentary Legal Service. The meeting stands at the end. Thank you very much.
Long live the chair.
Thank you,
Recording
Chair.
stop.
Happy Christmas. Thank you. Christmas in Chair.
Yes. Happy
portfolio
Christmas and
committee.
Merry Christmas.
DG makas arrangele ite portfolio committee.
Bolis,
Libuye nonke niphelele next year.
Hayi, masidibane sifuna iChristmas together. Volmarans, Zolmarans.
Leadership. The right.